The reason I'm here today is to answer questions about the current law on marijuana in Florida. By way of background, I'm not here because I want to get into the business. I'm not here because, frankly, I'll lose business with legalization. I'm not going into that field as far as the business aspect of it, but yeah, I don't like to be a hypocrite. I love marijuana for numerous reasons. I sit here today and I see the moms and everyone else speak, and it's just mind-blowing to me why we're in the situation that we are. I'd also like to thank Dr. Wilson King. I've tried to use the medical necessity defense before in Florida and have found the most difficult aspect of it is actually getting a physician to put their name and their good standing on the line for marijuana. And so I am going to be calling her and picking her brain and hopefully using her in a case or two down the road. Right, right. Well, fantastic. As I said, I spoke at the first time they had a event here. I believe it was the first event for the Cannabis Network. And the main thing, I don't mean to be a downer for everyone, but the main thing that I talked about then were the current Florida laws on marijuana, which are some of the strictest in the nation. Okay, can arguably be said to be more strict than federal law. The easiest example to put out there is possession of cannabis over 20 grams is a third-degree felony. So if you have an ounce of marijuana, okay, you're just using it for yourself. You have an ounce of marijuana, you could theoretically go to prison for 5 years. Does that happen all the time? No. But that's the background of what you're dealing with. Again, I'm here today to answer questions from y'all. I'm going to let Dominick speak and introduce himself a little bit and let him tell you a little bit about what he's about.
Thank you, Jason. I don't know if any of you heard me before at this event or perhaps at the Orlando event, but I'm attorney Dominick Fariello. I'm also known as Ask the Dom from 102.5 The Bone, a local radio station here. I'm the legal counsel for the Mike Calta Show. And then I have my own show on Sunday mornings that airs from 9 to 11. This Sunday is particularly important because an attorney who had a conflict who usually speaks at this panel, his name is Sean Gerhardt, a very, very nice man, an excellent attorney, usually gives an introduction on the business side, the legality of operating a business once the implementation, which we believe the law will be implemented in November, it will be passed. If you tune in this Sunday, he is going to be on the air co-hosting with me. His company goes through the process of setting up a legal business to sell, distribute, cultivate medical marijuana. And he puts up a business model and a business plan, which I think is just a wonderful part of the legal segment. And unfortunately, he just had a conflict today. So if you can tune in, you can hear him. What Jason and I do, unfortunately, is if you screw up. We are predominantly criminal defense attorneys. Sean's company, the firm, on the other hand, would be more preemptive, how to set up the right business model, plan, get all the paperwork in order, so once the law passes, which we believe it would, then you kind of hit the ground running. One of the other things that Jason didn't comment on that I notice that my clients really freak out about with marijuana possession is that if it's a conviction on the record, it could suspend your license for 2 years. So again, you're looking at the different amounts as far as if it's a misdemeanor or felony, and of course that's a concern. But a lot of folks, well, wait a second, I don't want to lose my driver's license, and if they don't have an attorney, and if they try to resolve the case themselves, and they get an adjudication, well, be careful, because then you're going to get a notice from the Florida Highway Safety and Motor Vehicle Department, and you're going to have a 2-year license suspension issue. What we usually do when I'm here, well, of course, is always field and answer questions. but we're here to kind of guide you through a little bit of what you need to plan and how to approach it. Because right now it's illegal. Federal law says you can't do it. If state law says you can and the feds don't implement that, and I know there's a letter that has about 7 things that the guidelines are that they'll look into whether or not you're using it to mass produce or sell it, or if you're using it as a front and all those other things. But if you have any questions, because I know it's you guys have been here all day, I don't want to say you're tired, but you're probably tired. If you have any questions, we can just jump into those, because if not, I can be here with Jason for the next 7 hours. Yeah, go ahead.
I can tell you this. I've read Jenks a lot. It's on my website. I have used Jenks in cases in Hillsborough County, not to try, because if you look at them and you actually go to trial on it, and they'll look at you like you're crazy. I've used it on clients that I've had. I had a incomplete C4 quadriplegic who picked up 2 cultivation charges. It's kind of an interesting story. Someone was breaking into his house. He called the sheriff's office out there. He had a grow. The sheriff's office, which is my favorite law enforcement agency of the ones in our area, actually did the semblance of the right thing. They didn't arrest him that night. They saw he's a quadriplegic. Okay, they said come down to the station, in a couple days, and we'll go through and start everything there. Well, they started the prosecution of him, and then they went out to his house again and found that he had restarted his grow. Now, this is somebody who, like the stories that y'all hear, was prescribed numerous narcotic drugs that left him like a zombie. He really could only function on marijuana. We were able to use the medical necessity defense with the prosecutor there, who happened to be a somewhat forward-thinking prosecutor at the time, and just get him probation and get him out of here into California within 3 months. Now, it's very difficult to use it, as I alluded to earlier. I called doctor after doctor, okay, people I found on the internet that might be associated with LEAP, the law enforcement against prohibition. Other agencies. There's an agency up in Virginia that had someone here at USF that was on their board. Nobody would come and put themselves on the line. Okay, I had to threaten them essentially. I called up my contacts with Normal and got the name of some people out in Seattle that would come down just for their costs, and gave them all this information to use it. But my experience has been, it's been very hard to use Jenks as is. Under your scenario, the Jenks case is extremely limited, okay? If y'all don't know the background of the case, it's an older couple where one of them contracted HIV through a blood transfusion, and then the other one got it. They had nothing. They were prescribed numerous medications. Nothing helped. The wife in particular was down to something like 80 pounds, and they started growing marijuana just for their personal use. Well, the courts made an exception. Medical necessity defense said it's viable in those circumstances. So the worst circumstances that you can think of. I cannot see it being used successfully as a medical, I don't think you're going to be able to use Jenks if some types of products are available with marijuana. I don't think you're going to be using it if you get caught on the corner with the joint, even though smoking it may be the best way for you. I think at that point, if any of the cannabis is legalized, I think it's going to take away from that defense, because they're going to say, okay, well, one of the things is you now have other options, so you don't need to be smoking this joint on the street. I don't know, but that's what I think will happen.
A lot of these cases are going to be a first impression. So if you have a prescription, which obviously if you qualify for that, if the law passes, that is the first step. But quite frankly, what the courts are going to do is take each case, and each lawyer is going to have to argue and expand upon whether or not Jenks is going to be a more broadened sensed case rather than narrowly tailored. So the problem that you have is, as you listen to us, and a lot of this is, well, we really just don't know what's going to happen until it happens. You know, we can guide and kind of preface you guys a little bit on, say, well, remember, the federal law says this, and Florida's catching up here. So to answer your question, that is an argument that has to be formed. And if, God forbid, you are arrested, and whatever your last name is, that might be the next case for everybody else behind you. And then you'd be famous.
But
in theory.
But honestly, it takes a client with a lot of chutzpah to actually go through and take it to trial. And that's something that I would love to do the medical necessity defense at a trial. I would love to do it, okay? If I won the case, I would be lauded all over the place. People would love me, okay? And I would have done something good. But when you go to a trial in a criminal case, it's not Dominick or I that are on the line, okay? We're going home at the end of the day no matter what. So if you're going to attempt to use something that's going to be established in case law as a defense, you're putting yourself on the line, okay? You could use it. The jury could say, well, we're not buying it. You could be convicted. You could be sent to jail. Then you're having to deal with appeals while you're in jail, most likely. And you put a lot at risk as a potential client in that situation. So that's why I think that you don't see a lot more. I mean, Jenks is what, a 1989 case? 88 or 89? 91? Okay. I mean, there hasn't been a lot. I mean, there's one or two other Florida cases that even really mention it. A couple of county court cases out of Broward. The Sour case, I believe it is. But there's not a lot of case law on it because people put themselves in a lot of risk if they were to go forward with it.
A question that I have is, how many of you are going to have a business in Hillsborough County by a show of hands? How about Pinellas County? Pasco? All right, so different parts, you're spreading out now, different parts of the state of Florida, I would assume. The advice that I give each and every one of you is the same that I told the group that I spoke to in this room a few months back, is you have to know the folks and the temperament in that county. In my humble opinion, Hillsborough County is a very liberal county. Pasco and Pinellas a little bit more conservative. Polk is extremely conservative, especially with the sheriff there as far as drugs and the prosecution of drug-related offenses. Hernando County, as you get to more of the rural counties, compared to more of the larger city counties, are going to have a distinction. So you need to know what county you're in, how law enforcement's prosecuting these type of cases, if you will, how the state's attorneys, the judges are ruling on this. That is going to give you at least some guide or semblance of what you would be facing. And I think you had a question there, and I cut you off. Sorry. I would be cautious on suing government entities simply because it's a pain in the ass. There is a sovereign immunity cap when you sue a government entity, but I think more or less what you're calling is about the principle of it, and then of course if you're dealing about a class of people such as the recreational aspect of it. Well, there's going to be a lot of debate, and I think a lot of litigation with regards to what the state of Florida is going to do after this election cycle. How that compares to the federal guidelines, and if the federal government is going to do or say anything with Florida, how they've interacted with Colorado and Washington is going to be guideposts, if you will. So I don't want to not answer the question directly. I just don't know if there's a direct answer because it has to play out.
I'm interested to find out myself.
I wish Sean was here because his firm, the Reisman Law Group out of St. Pete, they deal with a business side of things, and incorporated in that is tax, Bankruptcy, I know that firm does. So a lot of financial implications. So if you are able to tune in to the show this Sunday, you're going to hear him. One of the other partners in the firm is also going to be on the show because I think that's probably a better question for them. And of course, you can always email them or me, and I can get you in touch with them.
It's a good show. You also watch.
Thank you. You can watch if it's during the week on the Calta show. That's taped. I don't have all the fancy stuff yet. I haven't worked my way up to being the #1 rated show in the Bay Area like Mike's show. We're still down here somewhere.
You look at Florida. Florida has a huge population of elderly people. We have a huge pharmaceutical lobby. You look at who's fighting Amendment 2. Who are the two top industries that are doing it? The pharmaceutical companies and the prison industry. Okay, the private prisons or the prison industry is giving tons of money to try to get Amendment 2 not passed, just like the pharmaceutical companies. And to me, when you hear that the prison companies are lobbying against something, there in and of itself proves how ridiculous their side is, what they're doing. So.
Well, you got to understand something. You can't always justify the reasoning or rationale behind the law and say it's, I support it morally or ethically. The circumstances in the United States, they have certain things that are illegal. Now, for example, the federal government will choose not to enforce certain laws and regulations, which is why we have this whole immigration problem. So if you think about it in the context of the question, it's illegal to come into the United States, but there's people running in here and hanging out and getting more benefits than maybe some of us that are here legally. And you flip that on its side and say, well, why can't we smoke? There is no rationale to why they'll enforce something as opposed to not, or why it's there in the first place.
I can tell you to sort of answer your question, I'm not aware of a constitutional right that gives the government the right to forbid you to use cannabis. Now, I like to think of myself as a realist, but I'm probably, in terms of our society, a pessimist. I look at the Constitution nowadays and the rights that are given to you with the Constitution as something that this current government, this current Supreme Court, while they'll say they're for the Constitution and strict construction of the Constitution, they just look at the rights given to you in the Constitution as ideas, and they just want to mold how those ideas are to take place or to take form. And in doing so, whether it be a right to privacy, which isn't technically in the Constitution, but has been read in by, I believe it was Supreme Court Justice Douglas in the 60s. The way that the Supreme Court nowadays is working things is you have a right to be free from unnecessary search and seizures unless it's really a hassle for law enforcement. And then they'll find a way around it. I don't think you're ever going to find anything in the Constitution that you can say, this is the basis wherein the government restricts our marijuana use.
I don't disagree with your point, but until I run or Jason runs for federal office, I just don't know what politician you're going to need to have somebody or a group up there to make that initiative. I think what happens here is you start with so many states, and then in 5 years or 10 years, it's just going to get bigger and bigger, I assume. And then that probably point to be much easier, allegedly.
Does anyone know the medical basis that was used for the 1970 Controlled Substance Act that was primarily responsible for it being Schedule 1? Does anyone know the medical data that was used? There wasn't any. Okay, there was absolutely no basis in medicine at all to classify it as a Schedule 1 drug. Obviously, Dr. Wilson King would know that better than I would, but I know that from my research on it. So there's no rhyme or reason to why we are where we are now, other than certain people's interests and certain people's ideas with nothing to support it. So it is what it is.
Great questions. I mean, for a smaller group, you guys are much more lively as far as the questions than the last group. This is great. I like it. Yep. I think I've said this on the radio several times. I think DUIs are going to increase substantially. You know, from well,
right. I'm sorry.
No,
go
no,
ahead,
no.
please.
You're fine. You're fine.
Right now, if you have a DUID in Hillsborough County that has to do with marijuana, okay, you're not going to get. They're going to get the evidence of it through a urine test. So what'll typically happen is someone will get pulled over on the side of the road. The cops will do the field sobriety exercises. They'll arrest them. They'll go down and they'll blow triple zeros into the breath machine. And then the cop's like, oh shit, what am I going to do now? Okay, I'm going to request a urine test. Even though they're not supposed to unless they have some sort of probable cause or at least reasonable suspicion to believe that drugs are involved. Well, the good thing is when you get the report back from the Florida Department of Law Enforcement, they've just run a random, they've just run the simplest test they can on the urine. They don't quantify it. They typically don't distinguish in the type of cannabis or the type of they'll come back with typically come back with the non-psychoactive compound. Okay, 11 nor 9 tetrahydrocannabinol. You guys know it to see it. It will typically come back with that. The prosecutors will then say, "Well, we've got this. He is smoking marijuana." Well, they have no idea that in your system has no psychoactive effect. Okay, they have no idea when the marijuana's been smoked. Okay, they have no idea how much it is, and then they think that you should just go ahead and take the plea deal to the DUID because it's in the system. Usually, if you press them hard enough, they'll drop those cases, or at least give you a really sweet deal on a reckless driving with no real things to do, like just a withhold of adjudication and court costs. To answer your question about the specifics, there was a bill that was going to try and make it per se, if you have anything in your system, even the non-psychoactive compound, that's per se DUI. That didn't get past committee, I don't believe. So if you get I guess you got. Probably still going to be in your system. Yeah. I mean, if you're a regular smoker, best case scenario is 21 days. More likely over 30. And if you're a big guy, like both of us are, and you smoke marijuana regularly, yeah, it's going to be in your system for a while. And the judges here have no idea anything about that. The judge that deals with violation of probation, who I love because I generally know what he's going to do, but he has no idea about the difference.
Well, the reality is that you can smoke and you can smell like marijuana, and that's enough for them to pull you over. Well, they stop you for a.
What ruling was that?
Well, look, all I know is when I go to court every day and across several counties, if the clients get stopped for routine traffic stop, a tint, the seatbelt law, speeding, the stop bar, and
light on the license tag.
Yeah, even if the car smells like it, if you smoked in your car yesterday, but whatever the case may be, if you're at a party and you smell like it, I'm getting clients that are hiring me because they smell like weed. And what's going to happen is, even if this law passes, to go back to the gentleman's question here before, let's say you have a script for marijuana and you have a license to smoke medical marijuana if that's the law. I believe the DUIs are still going to increase because are your normal faculties impaired? And is that an inherent danger to the public and the safety on the roadway driving a dangerous instrumentality? So the clients are hiring me and Jason because they're getting arrested because they smell like pot in a traffic stop. And then now you got to spend the money for us. And then we have to go through the system. We have to fight or either get it reduced or have a trial or convince them to drop it. And I understand what you're saying. I don't think we are up here disagreeing because we're trying to help others understand the same cause moving forward. But the reality is these guys and girls are getting popped for this even before this passes, and they are going to get popped for it after it passes.
I agree.
All right, this is what's going to happen. Yep.
I work with other attorneys, and you guys are my favorite.
Oh, look at that.
And if I have trouble, these are the guys that I call. But I've heard that there's an increase in police arrests for misdemeanor marijuana possession. Some of the attorneys that I know said that it's up 30% in Ybor City, especially. Have you guys seen that?
Well, I'm an interesting person to ask that to. I mean, I had a case that went national news on my client whose car was broken into by the City of Tampa Police Department because a dog allegedly smelled pot coming from the truck, which was a truck that was about 6 feet tall off the ground with the big tires, and it was promoting the business, and no marijuana was found in the truck. That he was parked here at Ybor earlier this year. It was for a concert. There was a lot of people down here, and of course, when you have massive crowds, and it's a concert, and it's Ybor, you're going to have the odor and aroma of marijuana. And they thought it was emanating from the truck, which it was not. They tore the truck apart. They found nothing. And the Mike Calta show ran the story, and all the news media picked up on it. It was commented by Sean Hannity, and I think made it all the way to Rush Limbaugh. So yes, they are more proactive in this area for that element crime, in my opinion, even if you're not in the car, by evidence of that case. And I don't know if it's right or wrong. It's just what's happening.
I agree.
I yield. I mean, you have a comment?
I agree 100%. I have seen, I don't know, what did you say the time frame was?
Over the last 3 months.
Yeah, I've seen it in the past month in my business, but yeah, it doesn't surprise me. I mean,
yeah, the case that I had, my client wasn't stopped. He wasn't around the car. He was at the concert. They perceived the odor was coming from the vehicle. They then called the police dog, and they broke into the truck. It wasn't there. They tore apart the truck, the paneling and the interior, the wiring, all that jazz, and they found nothing. There was his girlfriend's purse was in there. They emptied the purse contents out. They found nothing, which, of course, he comes back and he thought someone broke into the truck. And what the officer did is left a handwritten note. This is Officer so-and-so with the Tampa Police Department. We've searched your truck. He said, well, what the hell is this? And, of course, he calls, me, and it calls the show, and then it goes from there. But your point is that I've got several cases in the office now where it was routine traffic stops. Routine. And they roll the window down and they smell the marijuana from the car or from them. And some people say, no, you can't search the car, and then they are arrested, and then it's a search incident to arrest. Some have the plain view doctrine where they can see the baggie in the center console, the cup holder, or wherever it is, and then now they have the right under that. Some say, yeah, go ahead and search, and then they find whatever they find. And what happens now is if the DUIs go up, which I think they will, if the law passes, which I think the law will pass, and people are going to say, well, I have a prescription for marijuana, but now are my normal faculties impaired? And what I do is I have to hire a toxicologist. And then that goes right to the point that Jason made, because then we take it to the prosecutor and say, well, We have evidence, toxicology reports, and I have a witness that can say whatever he had in their system does not necessarily rise to the level of being impaired beyond your normal faculties. And then that is where you do those motions to suppress and things of those lines. So it's happening here under those set circumstances. Do I agree with it? Do I disagree with it? It's happening.